Quorum. I'd like to call the Value Adjustment Board for Brevard County to order. First, we'll have a Pledge of Allegiance led by County Commissioner Atkinson.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, I'd like to verify we have a quorum.
Yes, sir.
Do we need to call roll?
We don't need to.
Okay, we do have a quorum. And we have as first action item approval for the minutes of August 2nd, 2024. I guess we have the authority to do that. Is there a motion?
Motion made.
Motion by,
Second. Sorry.
we have a motion and second. Any discussion? All those in favor signify by, do we call a roll or can we voice vote?
Voice votes are fine.
Okay. All in favor say yea. Opposed, nay. Carries unanimously. Okay. Our first item on the agenda is the Value Adjustment Board Attorney, and I think this has been a great respite. We had a meeting that we canceled to come here. It gave me and some of the other boards, and that was the main reason, time to kind of look at the system and evaluate the way it works. And I went online and reviewed all the cases, read special master's reports, and I have to say I was very impressed. It's a new way of doing things. I was here before when we heard the cases one by one, individual by individual. But I'd like to first have kind of a little orientation as a adjustment board so we can kind of answer any questions that you may have. So I'd like to introduce our Value Adjustment Board Attorney, Aaron.
Good morning, everyone.
Okay. Are you going to give us a presentation, or do we need to approve our legal counsel one-year extension of the contract?
I don't have any report,
Okay.
so the next agenda item would be the contract.
Okay. Any discussion on the contract? No discussion. Is there a motion for approval? Motion and second approval. All in favor say yay. Yay. Opposed, nay. It passes unanimously.
Thank you.
So what I'd like to do of our newly renewed attorney is to have him give us a briefing, kind of a little orientation about who we are, what we do, and why, and what we can do, what we can't do, a little bit about the process. We had a brief discussion earlier, and
Sure.
I think you'll find it very interesting.
Sure. So the VAB is a quasi-judicial body, sort of like a judge.
Okay.
Is
Yeah,
my
that mic's
microphone?
Okay.
Do I need to?
Yep, it is.
Testing? Okay, thank you. As I was saying, sort of like a court, but informal. The VAB is a body that takes appeals on property tax issues. So if a taxpayer disagrees with the valuation determined by the property appraiser or any sort of exemption, classification, or other property tax issue, they can file an appeal with the VAB. It's always optional. No one has to file a petition with the VAB. And any taxpayer can go straight to the circuit court if they prefer to. And they can also go to the circuit court after the VAB process if they disagree with the VAB's decisions. Before the board today are the recommended decisions prepared by the board's special magistrates. The board appointed those special magistrates at the organizational meeting. And before today's meeting, each of the recommendations before the board went through the full process. There was obviously a petition filed, followed by an evidence exchange process and an evidentiary hearing before the magistrates, who then produced the recommended decisions. The board's role in counties like ours that use special magistrates is limited compared to the boards that hear petitions directly. In those cases, the board makes all of the decisions and prepares the final decisions directly. But when those are prepared by special magistrates, the board's role is limited to determining whether the recommended decisions comply with law. So if there is something that does not comply with law, this is the board's opportunity to point that out and direct myself with the board's majority approval to basically speak with the special magistrate and prepare a recommended decision that does comply with the law. Today is not a hearing on any particular petition. It's not an opportunity to take evidence or hear argument on any particular petition. That opportunity has come and gone with the hearing process. But if the board or any of the board members have any issues with specific petitions, the board can address that today. I'm happy to take any questions.
Address that.
So the sort of how the board would go about making a recommendation.
Yeah, just for curiosity.
Okay, so yeah, if say the board a board member had an issue with a just value decision, a case where somebody appealed the property appraiser's value determination on their property, maybe they felt the evidence was not properly identified, or maybe it wasn't admitted when it should have been, or the other way around, or maybe just disagreed with the conclusion, what the magistrate's recommending that the board do. The board member just tells me what they want, and if the board of a majority of the board approves that, then I will make sure that the decision becomes compliant. The next step in the process would be to have another board meeting at which the board will have a chance to approve that revised recommendation. And then only at that point can the board certify the tax roll, because we do need to have 100% of the recommended decisions approved before we can do that, which is really the final step in the cycle.
If the board, the Value Adjustment Board, disagrees with the magistrate's recommendation, we have the ability to override that.
Yes.
And if that's litigated, are you the one who represents the VAB in court to litigate that?
So if a petitioner or the property appraiser appeals the VAB's decision, it'll go to the circuit court, but the VAB won't be a party to that case. That'll be more or less between the property appraiser and the taxpayer. There are other sort of nominal parties, but the VAB is not a party to that, so I'm not
Interesting.
involved.
So you're not involved
I'm
in
not
that,
supposed to
really?
be anyway. It does
Yeah,
happen occasionally.
but your involvement is strictly representing the VAB in this process.
That's right.
Okay, interesting.
Chair, may I ask a question?
Yes.
So in that process, if there's one that gets pulled out, say for instance, and it starts running, they can't separate that from the entire tax rolls? The tax rolls have to be held up until that comes back from the circuit court?
No, that would be a different situation, because at
Okay.
that point, the VAB would have already certified the tax roll.
Okay.
So we don't hold up the tax roll if we have a disagreement with the recommendation of the special master?
That could, or that actually would, because we've got to have all of our recommendations adopted and made into final decisions before we can certify. Up until that point, it's not final, so there could
But I know
theoretically be changes.
we talked about a case that is still unresolved. Obviously, we passed the tax roll, so if a case is being litigated, that wouldn't hold up the tax roll.
No, if let's say a petitioner appeals the VAB's final decision, there's no that won't delay anything on our end. The tax roll can be certified because that case would have already had a final decision from the VAB.
So,
They're appealing that final decision.
right. So we make all our final decisions. If we have a difference with the special master, that would not hold up the tax roll.
That would. So sort of the two
I'm kinda
different
confused here.
points in the process. So first, and what is before the board today, is whether to adopt the recommended decisions, which then become final decisions. Once all of those are done and all the recommended decisions become final decisions, then we can certify the tax roll. If after that point, one of the petitioners on one of those final decisions, or the property appraiser, disagrees, they can appeal to the circuit court. That won't affect the tax roll. The board's work would already have been done at that point. If they win, it could go back and affect it retroactively,
So let me
but it
ask,
won't slow things down today.
maybe I'm not asking the question properly. So our role is to review these 300-plus cases. If we have a disagreement with the special master and we vote to not agree with that recommendation, you're saying if it's just one case, that would hold up the entire tax roll?
Yes.
So let's say we do that. What's the impact of holding up the tax roll?
Well, the most obvious one is we'll have to come back for another meeting after the recommendation's revised. And then if the board approves it at that point, then the board can certify the tax roll
Approved by whom?
by the board.
Okay, okay, I understand. So we finalize that disagreement. We have a disagreement, we come back, we ratify that, and then it's certified for the tax.
Yes.
I understand.
Mr. Chairman,
Yes.
what is the normal time period that we actually are supposed to approve the tax roll? When does it become inhibitive of, like, when does it become an issue?
I would say we need to have it done before June in any event.
That's the usual deadline date that we would have to come back, approve it. So say there's a issue where we send it back to the special magistrate to review. Special magistrate then brings it back to us. That would all have to be before June 1st, is what you're saying?
Yes. That,
Okay.
that would be my hope.
Okay. And these are all legally noticed meetings that usually take 7 days ahead of time on it, or?
The board meetings?
Yeah,
Yes.
okay,
There's no rule that says it has to be 7, it's reasonable
I
notice,
understand,
but
I
yeah,
understand.
yeah.
okay. And then the idea would be that we say that there's something wrong with one of these tax rolls, and we send it back to the special magistrate, and the special magistrate, based upon what we say, we would have to give guidance and the reason behind it. We
Yes.
couldn't just pull it up and say, well, I think that this one's bad, and send it back, right? It has, and that legal guidance has to be based on process and law? Is that what you said? I heard you say that.
It's got to be compliant with the law. So
Compliant with the law.
what the board ideally should be identifying is something that does not comply with the law
Sure.
about a recommendation, and then we can fix that.
Okay, got it. Makes sense, thank you. Mr. Chair, thank you.
Okay, good. All right, any other questions? There is a portal that the board can, and you can review any of these hearings and read the special master's report. And it's very thorough, and actually even listen to the hearing if you wanted. I've gone through a few of them. It's very thorough, very complete, very well done, and actually very interesting. Some of these cases are kind of interesting. That gets into some real interesting issues, yeah, and especially the exemption side of stuff. And so we do have that option to look there. Now, there's ex parte communication. Maybe talk a little bit about our restrictions to ability to talk to people and how we hear evidence.
Sure. Board members, special magistrates, the clerk, myself, none of us can have ex parte communication with either side, so we can't speak one-on-one about any particular case with either the property appraiser's office or the petitioner or their representatives on it. If that happens, if one side communicates to the VAB or a board member, for example, directly without the other party present, that communication needs to be provided to the VAB clerk, and then the clerk with myself will deal with it. Basically, it has to be disclosed to the other side. They have to have a chance to comment on it before anything is done by the VAB.
Okay. All right. Now our next items. Do you have? Yes.
So prior to the meeting that we had today, one of the petitioners came up and was speaking. Didn't get into the specifics of the case at all. I was told that not to do that, but I wanted to let you know that that happened. If there's anything I need to do to make sure. I didn't know that that was a rule.
If it was, if you learned anything about a specific case, the best thing to do would be to just disclose that to the clerk.
Yeah.
And then, but if it was non-particular, if it was just maybe about a general VAB issue or a property tax issue,
Yeah.
that I don't consider that ex parte because it's not about a particular case.
Okay. Yeah. Yeah, somebody gave me a warning and I said, okay, well, I'll stop. That was good. Nothing really got into it. Good. Thank you for that.
Okay. Any other questions?
Nope.
Okay. Now, I have in the agenda board reports. I assume none of us have any reports since this is our first meeting.
I don't think we have, we've received any.
Okay. I am trying to get online to look at the cases, and it's not allowing me to do that. I might ask you to help. I have internet access, but for some time, But I just got online in the building over next, I was able to pull up the cases and look. For some reason, that's not working right now. Maybe I'm clicking the wrong button. Okay. I get all the other websites. Everything else working.
These usually take about 5 minutes.
I'm on this. I put on my hotspot. Mhm. Yeah.
No, I think with that, and it's interesting
Now it's in
because
that Smith
I've been on this board now for
But it was
3
full of
years.
this
Nobody
sad.
actually ever explained the process. And when I spoke to Tina Deskovich before, she said, yeah, I tried to do this before where, and I don't have, like, there's not a single case that I'm worried about. Like, if somebody brings
I
something
don't
up,
know if we
maybe,
can use these computers
but
that
I was
work.
there's this process. I never knew that we could do that.
I don't know the password to get on here. This is the one I use.
And sometimes you don't get to make that
I didn't know
ultimate decision.
that.
You just ultimately decide
Yeah.
special magistrate decisions.
Okay.
So if you don't like, say, like the way a special magistrate's doing business, then the next year you appoint somebody differently. That's the way to do it. And I'll be honest with you, I think just like our staff does to us, they're not doing it. But if there is an opportunity that, like, say, Commissioner Thad or you or somebody wants to review these tighter, we should move this meeting of certifications and all that stuff back up and have them meet a little bit ahead of time so that we can have that window. Because one of the things that stinks when we're on an elected official is that we have that window of, like, all of a sudden we got to make a decision and we're like, okay, well, we'll look at this. And we're like, well, if you don't decide it today, we'll do it in 2 days. You know what I mean? You know how you get that. It's horrible.
The thing is we have to trust that the staff
Right.
is
It's doing the
making
right
that
thing.
Aaron is
Right.
protecting us.
Yeah, yeah, yeah.
He's
And
not
that's,
putting magistrates in front of us
Right.
to approve that aren't.
and I understand that. In my case, inside a school district, we don't have professionals. We don't have the professionalism in some of our cases.
Well, I was going to show the board how you could look at these cases, but unfortunately, the system's not working. So we'll move on to new business. Oh,
Public comment.
we do have citizen member Rob Adams here. And that was going to be my next question. So every applicant is notified of this meeting, and they have the opportunity to address this. They're not individually notified?
Unless they call and ask us, it's on our website when this meeting is, so, but unless they call us, because when they get their recommended decision, this meeting is not always set up at that point in time. And we don't go out there and contact, say, the 400 people and say, the board, the VAB final meeting is on this date. If they call and ask, we give them the date. It's in the newspaper and it's on our web page. So when they go in to look at their own case, because they all have access to the same thing that you have access to, but their own case. So they can all go in there and log into Axia and see what's going on. So when they get to our webpage, they know when the board meeting is happening. We do have one public comment speaker today.
Okay.
So for item F under public comments, we have Jeff Smith.
All right.
How long are public comments?
Historically, it's been 3 minutes, but it's in the board's discretion.
3-minute public, but the time is of board discretion. So, and you're the only one, so.
Well, board members, thank you for the opportunity to speak to you today. I'm here on behalf of property owner and taxpayer Alex Berkovich, and it concerns a property on South Tropical Trail that he purchased in 2020. It's a house on a 6-acre site. Subsequent to his purchase, he is now, as a result of FEMA mapping floodplains, he's in a floodplain. It's affected the value of his property, and that was the central issue that went to the special magistrate. I'm going to hand you a copy of the special magistrate's decision that I've highlighted some key pieces of.
Thank you.
If you'll direct your attention, so what we're here to do is to raise with the board what we believe was the erroneous conclusion of law by the special magistrate. And it's a unique issue because the magistrate actually made the correct conclusion of law, but then at the end made a conflicting conclusion that doesn't make any sense, and you'll see in just a moment. But the issue was that the property appraiser's office came forward with comparable sales and had determined that the age of the building, if you'll take a look at paragraph 10, it's highlighted, and it says the first material issue in dispute is the age of the building. Property appraiser's office claimed in testimony and in evidentiary documents that the dwelling was built in 2023, whereas the petitioner claimed the dwelling was built in 1985. Photographic evidence shows that the dwelling was not built in 2023. This error demonstrates a potential misunderstanding of accepted appraisal methodology by the property appraiser. Given this error, the property appraiser did not and could not properly consider the factors of Florida Statute 193.011 and employ appropriate methodology in developing the assessment. Accordingly, the assessment is not entitled to a presumption of correctness. Spot on. He's absolutely right about that. And so what that did is now the property appraiser has not put forward a valid property appraisal methodology. And so it opened the door for the taxpayer to present a methodology of.
Go ahead, proceed.
And I'll try to shorten up here.
No, you don't have to. I mean, you're the only person you've taken the time to come here. I appreciate you doing that. I mean, if we had 100 people sitting in the room, we might.
And so what was presented to the special magistrate, because there aren't comparable sales that you can put your hands on of properties that are sold in a floodplain. So the comparable sales approach was not the approach taken by the taxpayer in putting on evidence. They used a cost-based approach that looked at the sales price of the house, which that was all in. These figures are not in dispute. The sales price of the house was $1,145,000. The improvements to the structure after the sale were $634,370. That comes right off of the property record report, and there was no dispute over that figure. The improvements to outside the house, there was an adjustment made of that, but it was $136,636, which means the total value would be $1,916,000. And then there was an undisputed amount of what it would cost to fill the property to bring it to above floodplain, which results in a 1.388 million value. And the special magistrate observed that in paragraph 12, but didn't give it any, he didn't credit that and said, no, you have to give a comparable. Well, there aren't any comparables of sales in the floodplain of this type of property, and that was the issue. And so What we're here to say is the only evidence that was presented was the only evidence that was not deemed to be an improper methodology, which I read to you that the special magistrate was clear that the property appraiser's office used an improper methodology to arrive at their figure. And then I think where the magistrate went wrong is at the end, after having already said that the appraisal of the property appraiser wasn't entitled to a presumption of correctness, that at the end of his report says, well, based on the cumulative evidence, the property appraiser's assessment is entitled to a presumption of correctness, which is just a conflicting, you can't reconcile the two findings. And the first one is the appropriate conclusion. They did not prove, did not put forward, which was their burden, to come forward with a proper methodology. Once they did not, it's the burden of the taxpayer to put forward an alternative appraisal, which they did. And that's what we would ask you to do, is to adopt what's in the record, the $1,388,256 as the value. And that is in the record. Thank you. Any questions?
In the written report that you submitted to us, does it have what you just asked us to do? And what paragraph would that be?
In paragraph 12, he
That's the
recognized,
reduction of the 1.9 million by the 527,000.
right, and there's that number, 1,388,256. And the only thing he does to reject it is say it was not corroborated by any value evidence, meaning I think what he's saying is that there wasn't a comparable sale to corroborate it. But what I'm saying is that's another alternative methodology, proper appraisal methodology, when you don't have comparable sales, is the methodology that was used, which is a cost-based approach methodology.
Okay, I have a couple questions. I don't know what my restrictions are. I know.
You can ask essentially anything you'd
Okay.
like. I would just sort of remind the board respectfully that this is not a hearing, so the board cannot take into account what's being presented in terms of making any potential changes to the recommended decision.
But
The-
we
the
can
record
take
is what
into
it is, in
account the
other
public
words.
record.
And I just want to make clear, Aaron, I'm sorry.
It's okay.
Counsel, that we're not departing from the record. The number I gave you on that sheet, those are all in the record, and it's, as I pointed out in paragraph 12, the special magistrate has those numbers in the record and in his decision. So we're not asking you to go outside the record to
I
find
understand.
something new.
That answers my question. Thanks. So a question I have then, sales price 1.45 million, improvement to the structure 600,000, total assessment 1.9 million. What you felt should have been considered as a part of this public record is the request to reduce that amount by 527,000. That is what it would cost to correct the flooding problem or the low-lying floodplain issues. Am I hearing that correct?
Yes, that's correct, and I don't think there was a dispute in the record as to that amount. I think the dispute was over, okay, the magistrate sees the value that we're putting forth and then says, but don't you have, where's the comparable sale? And the point of the taxpayer was, you can't find comparable sales of properties like this located in a floodplain that somebody has recently purchased. And so that was really the bottom line issue. And what I'm saying as a conclusion is that this is an alternative, proper appraisal methodology using a cost-based approach rather than a comparable sales approach.
So my question is then, you mentioned earlier about, and it's reflected here in the record, the improper dating of when the house was built.
Correct.
It was built in 1985. It was not built in 2023. That's in paragraph 10. How does that affect, does that relate to this disparity in value? Or is that just an assertion that,
Well, what it does is that the comparables that they were relying on included comparables of houses that were brand-new houses. And so it didn't make sense, and the special magistrate acknowledged that it didn't make sense and said, no matter, while repairs, remodeling, renovation might produce an effective age that's lower than a building's chronological age, no amount of repairs, remodeling, and renovation can transform a 39-year-old building into a 1-year-old building. So he's saying you can't use that comparable. You, property appraiser's office, did not use a proper methodology. It's not entitled to a statutory presumption of correctness. If they had followed a proper methodology, they would be entitled to do that. They would be entitled to a presumption of correctness. And he's
Okay.
making that finding.
very interesting. Any questions?
Yeah, if I can ask a couple of questions?
Yes.
Just process-wise, so this gentleman comes up, gives all of this evidence. Is Ms. Blinkley allowed to come up and answer questions too? Or does that get into that hearing phase that you were talking about?
That would be entirely up to the property appraiser. But yeah, again, this isn't noticed as a hearing.
Yeah, no, just for proper process.
But she could if she'd like.
That's her option, yes.
Okay.
And then the next question is the comparable sales and the cost-based approach both used in property appraising?
Yes, but in general, the cost approach, and I would argue that this is not really a cost approach. The cost approach is not typically used for existing structures. It's really more applicable to new construction, unique circumstances. And I understand that they're arguing that this may be unique. But I'm obviously not an appraiser, but the cost approach is not simply taking the other side's value and deducting some amount from it. It's what does it cost to rebuild the structure from the ground up. So I don't see this as being a valid cost approach, but also, I think more to the point, paragraph 13 addresses the issues being raised by the petitioner. The special magistrate found that after correcting for the age adjustment, so that resolves the age discrepancy, and deducting the $527,750 for the cost of filling, the property appraiser's 3 improved sales don't demonstrate that the assessment was excessive. So I'm not advocating for either side, but I do believe that the petitioner's issues were addressed.
I have a question. if I may.
Yes.
My question is a process question. So if you just told us that our job today is not to make any decisions on specific cases, what exactly are we supposed to be doing right now in regard to this?
The best answer I can give you is based on the presentation, nothing. That's the most direct answer I can give the board. If the board, regardless of the petitioner's presentation, finds that there's something uncompliant about this recommendation, the board can always direct that to be corrected.
Okay. Thank you.
I think that's a very good question. Do you have a response to that?
Yeah, I do think the Value Adjustment Board, this is kind of just a basic administrative law question. Happily, I practice administrative law, so the question, you as a quasi-judicial body have the authority to disagree with the special magistrate's conclusion as long as you're basing your decision on record evidence. And otherwise, we're not bringing in new experts or new testimony or saying, let's have a new trial. We're saying trial was had. The judge the special magistrate reached an erroneous conclusion, and it's within your purview to correct that conclusion and say, you're going to find that, just as the magistrate said, that the values that were used were not entitled to a presumption of correctness, and the value that the taxpayer put forward is an appropriate value to base the final appraisal on. And it's not going outside the record to do so. It's staying within what was presented at the hearing, which is what I'm confined to and which is what you're confined to.
I got a question.
Yes.
Was the taxpayer who owns the property now, was he aware it was in a floodplain when he bought it?
No, I mean, he wasn't in a floodplain when he bought it. FEMA remapped it and put it in a floodplain.
Oh, after the buy. Okay.
After the fact.
So, and then he went on his own dime and filled it.
He hasn't filled it yet.
Gotcha.
That's why they're asking for the reduction.
Sure,
Is-
sure, okay. I'm good.
Is the finished floor elevation of the structure in the floodplain? Or is
Now
it
you're
just-
asking me something outside the record that I don't know
Okay.
the answer to. I believe it,
If he's allowed. is he allowed to
Taxpayers
talk
here,
about
It's
that?
in the board's discretion.
Okay.
Thank you, Board, for taking the time. My name is Alex Berkovich. I'm the homeowner. To address the issue, when I bought the house with my wife in 2020, there was no issue with the FEMA, and I was able to get insurance. In 2021, 4 months after we purchased the house and began remodeling it, FEMA went overboard, in my opinion, and made my whole property a floodplain. Even the house now is below the required floodplain, so now I can't even get insurance. So I'm fortunate enough that I was able to pay off the mortgage because they figured out that I couldn't get insurance. They gave me 30 days to pay off the mortgage. But putting that aside, I've been arguing this point with the property appraiser for 4 years, and I kept losing and losing and losing. And I got tired of losing and arguing with an appraiser, which in my opinion was making the wrong mistake, making a mistake on this property. And the last hearing we had made it very clear that the magistrate was working with me and he was grilling the appraiser for making all these mistakes. Not only did he make a mistake about the year of the house, he compared a property next door to me at $3.4 million as a piece of land. Then we showed him proof that that $3.4 million sale was not a property alone. It was a brand new 7,000 square foot house, which is next to me, that is 14 feet above floodplain. So the property appraiser was grilled by not doing his homework. And if you ever get a chance to listen to the recording of this particular case, hopefully we don't have to go that far, but if we go further with the appeals process, the property appraiser was apologizing. It's like, well, we made a mistake. Well, if you're making a mistake and you're trying to take a taxpayer like myself and charge me double for the taxes, that was an erroneous decision. So all I'm trying to do is pay fair taxes. I've agreed to the value of the construction of the house, the repairs. We never argued. We agreed to the value of the boat dock and some of the other items that were added to the house. I never argued that. The only thing I'm arguing is the value that they placed on a piece of land that cannot be comped. When I bought it, it was comped. But now, because it's underwater, literally, and half the time when it rains, I can't use my dock, I can't use my front yard. I mean, there are other issues that we argued, but the bottom line is, I'm in the middle, the house is a little bit higher than, obviously, the rest of the property. But when it floods, when it rains, my house floods. I had 2 floods in the last 2 hurricanes, I flooded. And I had no insurance, which I had to pay myself for it. So all I'm asking is for this board, and this board has the rights to make a decision. Otherwise, if you guys just approve everything that the magistrate says, to me, it's a rubber stamp. Then what's the point of having this board and having myself and paying my attorneys to be here if you can't make a decision against the magistrate? Or at least look at my position with the evidence that was pointed and in record. I'm not asking you to look at new evidence. All I'm asking you is to be fair to a taxpayer. Thank you for your
I
time.
have a question.
Yes.
I do have a question. Thank you for being here.
Okay.
And
Do you have a
doing your
question for
job.
me?
Yes. So FEMA, if you fill the land, you're not changing the
No,
finished.
I'm still under.
You're still
I'm
in the
under.
floodplain.
To be frank, for me to do this correctly, I have to tear down the house,
Right.
bring in $1 million in dirt, because that 527, that was the bid from 2021. So obviously,
since COVID. So right now, to fill this, to do the same fill around the house is $1.4 million, not counting the house. So for me not to flood and to be able to get insurance, I have to tear down the house, go up 4 feet just on the house, put a brand new house, which is about $4 million to replace what I have. So I'm out $6 million.
And if you ever decide to sell this
I can't sell.
property,
No one's going to buy it.
you would have to disclose all that.
Why, absolutely. Well,
Yeah.
anybody who's going to do due diligence is going to see that I'm literally
Right,
underwater.
right. Hmm.
And we showed those documents to the magistrate. We showed photos. We showed timestamps. That was all given as evidence. So I'm baffled when he ruled against us, against me.
Okay,
Thank you.
thank you.
Board members, thank you very much for your time this morning, and I would just urge you to take this and make the decision to make the adjustment that's in the record and properly appraise the
So
value
I want
for
to
the-
ask you a question. If you could specifically give us the recommendation that you are seeking that this board take.
That the board vote to adjust the appraised value for the taxpayer's property to the amount of $1,388,536, if I'm remembering.
256, close.
256.
Okay,
And that's what our recommendation would be to the board.
okay. All right.
I don't think we can do that. We can only send it back down to the special magistrate, correct?
Correct.
Okay, but his question, can we do that? We can only send it back to the magistrate.
And the magistrate would have to judge based on those items. I'm sorry. I have to have this closer to me. Follow the process for us, please. If he makes the recommendation that he said that we would make the recommendation to adjust it down to $1.388 million, right? You, under your guide, said that we would have to send it down to the magistrate. Magistrate would have to look over the process, find out if there was anything that was different or law process or anything like that, and then bring it back. Is that the proper process? Or would, under his recommendation, us be able to just say, you know what, we're going to readjust it to 1.3 million?
I suppose the board has discretion to do either. Just a sort of a directive to change the value to a number without specifying how that number was reached would be, you wouldn't get a very good recommendation out of that. So, you know, I think more is needed.
Could I just address that and say that, I would amend my prior statement to say that you would adopt the finding from paragraph 12 in the magistrate's report and adopt that as the value that, using the methodology that was presented in the record. And just, I think then you have a record support. You're not going beyond the record to get there.
Thank you. Thank you. I have a question about the process. If we as a board were to recommend this going back to the magistrate, what would be the process?
The board,
A motion was made.
a
approved.
motion
Yep.
to change the recommendation in a certain way approved by a majority.
Yep.
I would then take that directive to the special magistrate, and we'd prepare a decision consistent with the board's directive.
Would it go to the same magistrate or a
Yes.
different, same
Same
one?
magistrate, and then it would come back before the board again at another meeting.
Okay.
And we would have to have a special meeting again to do this prior. And
Yes.
is that special magistrate review one that would include them coming in and making arguments and the property appraiser? It would just be, go back, redo it, bring it back as a tax roll and do it?
It's really just me and the special magistrate.
Okay.
And if I'm not mistaken, if the recommendation is, and that the vote of the board is to adopt that value, then it could be done that way, that you just adopt that value, and that is the final decision of the board. Thank you.
Is that correct?
What he said is correct. That would be the consequence, yes.
I have a question.
It's interesting.
And thank you for being somewhat of a guinea pig. And of course, our property appraiser, anytime you want to say anything, we'll give you an open mic. So, because we are a new adjustment board, And you were somewhat of a guinea pig in that we're learning and wanting to do this process in the most complete and fair way and legal way possible. And more of a question of law. So let's say we agree with this and we recommend that the numbers that was established through the public record under paragraph 12, something that we agree with, send it back to the special master. What does that give you in terms of the landowner as far as a benefit? It still has to go back for the special master. It still could be litigated.
Yeah.
What's the gain for you doing that?
Well, I don't, the gain ultimately is the reduction in the appraised value and the reduction in the tax burden on his property. So that's the gain.
But still, it could be litigated. You may
it-
not get that. The property appraiser could still contest that, and it could still be litigated.
The property appraiser could appeal the board's
Right.
decision. They have that right, just as the taxpayer has the right to appeal and
Right.
go to circuit court. It's a de novo hearing in circuit court. But this board has the quasi judicial authority to enter its order. This is what we're recommending. Your counsel can meet with the special magistrate, but the board's decision is the board's decision.
So my guess then, when the circuit court hears the case and they weigh the value of the evidence, our decision would probably be part of that weighing of the value. Is that, it would not be? I'm seeing heads shaking now.
There's two
So I'm
possibilities.
just saying, what is the gain? I
So,
mean, what is-
well, the possibility would be if the board enters a final order that says this is our decision, votes this is our decision, we're going to adjust the value to this, the property appraiser could appeal that if they wanted to the circuit court. They could choose, we don't want to appeal it. You know, we've been through the process. That's why we have a VAB.
Right.
They made their decision. We've been through the process, and we're not going to appeal. The taxpayer, if you didn't adopt it, the taxpayer could go and file a separate action. It's not technically an appeal of this action. It's a de novo hearing saying we want a circuit court hearing on the valuation.
And I guess as you look at administrative law, you've practiced administrative law. So
Yes.
No, you have to exhaust all your administrative remedies,
This is it.
and this is it. And obviously, whatever decision make would have some weight, I would think, would have to have
Yes.
some weight. Yeah. Okay.
I did want to make one point, and I may have already made it, but I'm not sure that if the board were to revise the recommendation today, whether that would comply with due process. This was not noticed as a specific hearing on any particular case today, so the property appraiser has not received any notice that this was going to be presented today. That is a concern.
But this meeting was publicly noticed, and we did
But
hear
but
that
there was nothing
people
on
could
the
look on the
Sorry.
agenda, and they had a right to be here. So what would we need to do? Schedule another hearing and call it an administrative hearing, or just,
If,
what would we
Well-
need to do to reconcile that?
for example, one, and maybe the most appropriate means of doing this would be to file a request for reconsideration. That would have had to happen a reasonable time before the meeting, so that the property appraiser had a chance to respond to it before the meeting.
So you're saying we're just here doing nothing?
No,
That we
sir.
can't do anything? I
No,
mean, we
sir.
have a school board member, 2 county commissioners, and a citizen. Why are we here? And we're here on the direction of Florida law and statute. We have to have some purpose.
I'm not saying that you don't, but taking up specific cases after they've already gone through the process, when there hasn't been notice of any particular
Then what are we
cases,
here
is a
for?
concern.
We're about to take up over 300 cases and give them a stamp of approval. So we have to just, I'm perplexed. I'm very perplexed.
Well, the board's role is to determine whether those decisions or recommendations comply with law. So if the board finds that this doesn't, I'm not saying the board can't, but public comment is not the same as
Yeah,
a
sure.
Yeah.
properly
I'm sorry.
noticed hearing.
Okay, I
Commissioner,
understand
if
what
you
you're
would
saying.
like, you
Yeah.
go for it. If you'd like, you got it.
I was just going to ask another question. is there a possibility that if this went back to the special magistrate, that they may look at it with different eyes, have a different thought?
I suppose it's possible. I mean, I would say it's unlikely, but,
Right.
it's possible.
If there's any more questions for me, I do believe that the board has the authority to enter a decision here, and then the property appraiser may appeal that decision if the property appraiser chooses to. The due process notice, I think your point's well taken, Mr. Chairman, is that the notice was the same as the 300 and some taxpayers got, and I think the property appraiser's office had notice and opportunity to be heard. I really don't see a due process claim there. Bottom line is, it's your call. That's why you exist. That's why there's a board to make to make these types of decisions. Thank you.
Thank you.
One more minute, I apologize. Unfortunately, I agree with my attorney and I disagree with the board's attorney. The board's attorney is trying to put this board in a position where you can't make decisions. And like the chairman said, then why are you here? Why are you wasting taxpayers' money sitting here, having you guys sit here and make no decisions? If this is a rubber stamp board, then just make it plain, Mr. Attorney. Say this is a rubber stamp board, 300 files, you can't look at them all because you can't get into them for some reason. And now, just go ahead and approve the magistrate. Then what's the point? I might just go to court.
Yeah,
and
go ahead.
now
I
we-
want to hear from counsel.
Yeah.
I'm sorry.
Can I ask a
Thank
question?
you.
Bottom line, I know we've taken a great deal of your time this morning on one case, and you've got 300 others that you need to attend to. So I just wanted to go ahead and wrap up. If there's any other questions,
Okay.
happy to answer them.
Very good. I see our property appraiser step forward.
Okay, thank you.
Good morning, Board. First, I have to say that I'm going to object to any additional evidence being submitted for this case because that part of the process has come and gone. I would also like a copy of that. I would also, it is my opinion that we are embarking on basically a second hearing. So to publicly notice a meeting of the Value Adjustment Board is not the same as a request for reconsideration where the property appraiser has an opportunity to review any additional information that is being submitted by a petitioner. So I will defer to your attorney on your advice there. I would also object to this recommended decision being remanded back to the magistrate unless you are doing that because the decision was deficient somehow legally, and if it was, I would like to know what that is. Okay?
So, but you're not disagreeing with anything in the special master's report, that there was a material issue in the dispute of the age of the building, that it was a material issue. It was presented that the building was built in 2023, but it actually is a 39-year-old building.
Chairman, I don't have that case. I don't have all the particulars of that case, so I don't know, what the circumstances were on this particular case. It sounds to me like there was an exchange of information. There was evidence presented by the petitioner. There was evidence presented by my appraisers to support our value, and a recommended decision was made by the magistrate. Now, what your attorney did say is that you certainly have the right to take a look at that recommended decision and find if it is legally sufficient. If it is not legally sufficient, and you decide to remand that back, that is the proper process.
Can you explain, or it might be counsel's explanation, this new process, because it's different than what she's speaking to, a new process, and this is just for me to understand. What is that to notice a meeting if it was a second hearing? What is that? Would that be you? Would that be her?
I'm happy to take it. So I think the request for reconsideration, is that what?
I guess,
you're
I
asking?
don't know if we'd even go down that road, but it's interesting
Sure.
to find out.
So either party, after the recommended decision is issued, can always submit a request for reconsideration. And that's exactly what it sounds like. They can point out something that they disagree with about the findings or the conclusions. Got to be reasonably specific about it. It's submitted in writing before today's meeting. Other side gets a chance to respond in writing so that they can, again, have due process. And then typically it would go to me just to make a recommendation and ultimately goes to the board. That has happened a few times since I've been here. It's not a common thing, but in other counties it is more common.
And just out of curiosity, so there's not a noticed time period, it's just a formal that they would have to, before this meeting, bring something like this in, say it's a proper process, object to what's happening, and then it would kick it back to you for review.
More or less.
Okay. And that's what you were speaking to, Ms. Blinkley?
Both, the request for reconsideration in the process and the opportunity for this board to make a determination on legal deficiency of a recommended decision.
Okay. I had one other question. In the event that we go to make a vote, because this is considered a small board, Robert's Rules of Order gives the chairperson in a tie the ability for a second vote. Is that pertinent to this board?
The VAB rules don't specifically reference Robert's rules. So to be honest, I'm not sure. I don't want to give you a bad piece of advice.
So in the event of a tie, the VAB does not give us a,
There's not a tiebreaker provision. I think it would go for another vote.
And if it's a tie, it's probably a rejection, a negative vote.
Okay.
My guess, of course.
in small boards, if
Well,
it's
but you
not
could vote
referenced, then it's
to make
usually.
a change here, or you could vote not to. If it's still a tie, then you don't. That's a good question.
Well, that's what I was
There
just,
have to be some sort of tiebreaker provision.
what does it reference for our governing body? This is, for me, from a perspective of this, it's just fascinating, all these little rabbit holes we're going down right now. But it doesn't reference Robert's Rules of Order to host this meeting?
It does not.
Does it reference any other kind of governmental,
I don't think so.
okay.
Robert's rules is usually used,
Yeah.
at least informally.
And what would it take to make Robert's Rules of Order our governing system? Would that be
At
us
a
just
minimum,
voting to do
well,
that?
it's possible a local procedure could be enacted by the board.
Mhm.
I'd want to give that a little bit of research, but that is possible. Short of, if that's not, it would at least have to be a Department of Revenue regulation.
Yeah. It's just interesting.
It is.
Okay.
Okay, well,
I'm not really comfortable making a decision with the fact that we have just been given information that our property appraiser doesn't have. So I'm going to make a motion that we send this back to our special magistrate.
okay. Is there a second?
I'll second.
A second?
Sure. I believe that.
Bob Springer, motion by
Floodplain.
Commissioner Atkinson. What's that?
Floodplain property is of a lower value than non-floodplain property. If he spends the $500,000 to fill the place up, doesn't his property go up by $500,000?
Can you
Okay.
walk through the process of that motion and what it would do? Her recommendation is to, that way we can all understand what she just made.
If I understand sort of what's behind the motion, board member wants the special magistrate to basically give it another review, a closer review.
Yep.
That's exactly what would happen if
And that's within the rules of this.
there's nothing preventing it.
So let me ask this. Special magistrate goes back and says, you know what, I already valued on this. I'm keeping it the same way. Comes back to us again with the same exact findings.
Yeah, we're getting in a do loop.
Would it be, so if we agree to do this, that sends that path. Is there any guidance that we can give him to say, hey, look at this process?
Yes.
Because I think what Ms. Blinkley's saying is that she's asking for some kind of a legal something.
I would just ask if this board is finding that there's legal deficiency in the recommended decision. Is that what the board has decided?
I don't think we've made any decisions.
Or has the board decided just to send the recommended decision back to the magistrate because you're not happy with the value conclusion?
Is it legal for us to do either of those?
Correct. I think that's correct. I think what you said is correct.
I think it's
Which
her
part?
motion, though. It's her motion, so she has to explain it. But what Ms. Blinkley just, and am I saying this correctly by saying Ms. Blinkley, or would I say?
Blickley.
Blickley, sorry.
Yeah.
Ms. Blickley, would I reference you in any other way? Property appraiser,
Dana works.
Okay, Dana,
Dana.
that's what I figured, Miss Dana. So Miss Dana just made a point, is Commissioner Atkinson's request valid enough to go back? Is that legal?
I think it is legal. I
Okay.
don't know that it's likely to change anything, candidly. And so I think it's kind of outside of the scope of the property appraiser's concern, if that's the right word for it, that it's not, that the board is not making a determination that something about the recommendation is legally insufficient. So I don't take the motion to be that sort of a thing. If the board is making any sort of direction about what must be changed or corrected, for example, then there would need to be some finding of legal insufficiency. But if it's just essentially take a harder look.
That's all my motivation.
I think that's different, frankly.
And if that was sent back, then they would make that recommendation based upon our findings, like, hey, we felt like this needs a second look. They look at it, then they bring that back. Normally, how long would that normally take in order to do that? How fast could that happen?
I would say a week would be
Sufficient?
more than enough typically, but I don't know what the special magistrate's doing right now.
So if the motion does pass, I would ask if we could check our calendars to make sure that we could come back in 7 days so that we're on pace with not holding up the tax rolls would be the first thing. Second thing is that once it comes back, if we don't like the way that it is there, can we make another recommendation to send it back? Just saying.
I don't see, again, I think we'd be in the same position. So yes, you could send it back yet again.
Okay.
But we can't direct the magistrate.
You can, if you find something legally insufficient about
That's
the
right.
recommendation.
That's
legally
what-
insufficient.
But what they're saying is that he's making an argument on one side that this is legally a sufficient argument for this number 12, and I apologize you haven't been given this. Do you guys have another copy for this for her? From Miss Dana, sorry. I think it'd be fair for you to have it. The other thing is so could we say that 12 is sufficient of a legal argument to take a look at that? Would that give the direction that
I think
the-
points of emphasis probably don't cross the line, but it would depend on the exact wording of the motion, frankly.
Okay. You did,
You have a friendly amendment to my-
I was going to get there, maybe. I don't know. I'm just legitimately going down these rabbit holes because I find it fascinating right now.
So I just want to make sure I understand. Are you asking for basically a reconsideration with the new evidence that is being submitted today and the testimony that has been submitted today to the magistrate?
I think-
Or are you sending back the same information that was heard for the magistrate to make a change of opinion of value,
I think-
perhaps?
That's a good question. I think if there is a friendly amendment or anything like that, it would be not to submit new evidence, but actually submit the same evidence that is brought up here. Meaning that if they wanted to look at a specific portion of what was inside of the findings, that they could, but we're not submitting any new evidence. We're not telling them that they have anything new. That would be what I would think if I was going to do a friendly, but I don't.
Was the
happened.
information today considered evidence?
Let me ask you a question, By this document you gave us, is that just the copy of the special magistrate's report?
That is exactly
So
what it
this
is.
is-
With
And I just want to
highlighting.
be clear.
With
that
highlights,
This
but-
is being recorded. There has been no non-record evidence submitted to this board. Everything that you've got is in the record that was before the magistrate, and we are asking that you make a decision that there is an irreconcilable conflict in the magistrate's order saying that he did not follow, the PAO did not follow the required methodology. It's not entitled to a presumption of correctness. You can't reconcile that with the decision. And I think this board has the power, and I'll just end here.
This is nothing new. This was presented in public.
This
It's
is
a-
nothing more than the magistrate's order.
Okay.
The bottom line here, the buck stops with this board. Either this board is just a perfunctory body,
Right.
or it's not. And I tell you it's not. You have the ability to say, we've looked at everything, here's our conclusion, we think there's a legal error in the analysis,
This is just a-
irreconcilable conflict, we think that this should be the decision, it's all there in the record.
Okay, great.
So I'd just
I
like to
agree
say
with that.
two things, and they are general statements. They are not related to this particular case, because I'm not in a legal position today to rehear a case or rehear evidence on one particular case. There are thousands of petitioners that go through this process that have to follow all the procedures and submit their evidence timely so we can review those. But let me make this general statement. The property appraiser's budget is not based on the amount of value or taxable value in a county. There's no incentive for me as the property appraiser to have a value higher than it should be or lower than it should be. We also don't appraise property on anybody's ability to pay. That's not the way that that works here. So just so you understand, there's no incentive. Also, Chair, I think the big difference in the process from years ago is that for counties this size, for the amount of time it takes and the expertise needed in this county of this size, you hire certified appraisers to review these cases, to review the information, because they are the experts in those fields, and you hire attorneys to hear evidence based on the petitioners and the property appraisers' determinations of law in applying exemptions or agricultural classifications. So that's the reason that there's a separation, if you will, for the experts in those fields to make those recommendations to this board that presumably don't have that expertise. So while I understand it can appear perfunctory, I believe, and I don't want to speak for your attorney, what your attorney said is, yes, you have the authority if you find legal insufficiency for any recommended decision or any part in the process, you have the ability to go back and review that. What you don't have the ability to do today is rehear a case, to accept any evidence or any testimony that was not given at the time that the appraiser that you hired to hear the case heard. Okay? Thank you for your time.
Thank you.
So, reading from the Department of Revenue site, the purpose of the Value Adjustment Board, the VAB, is to hear appeals regarding property value assessments, denied exemptions or classification, ad valorem tax deferrals, portability decisions, and change of ownership or control. Taxpayers or their representatives file petitions with the VAB in the county where the property is located. So we have a job to hear these appeals, and if we feel that some anomaly is in place, we need to come to the finding. In my opinion, there's evidence that's been presented at the Value Adjustment Board. We're not hearing any new evidence whatsoever. We're only evaluating the report from the special master, and there appears to be some inconsistency, and I think this particular property owner is due the benefit of having the VAB to acknowledge that as we're allowed under the law.
So if we give, Mr. Chair. Question.
Yes.
So if we allow the special magistrate to have a relook at this thing, it will still come back to us to make a final decision, because you've just said that's our job.
I mean, our job is to hear
Right.
appeals.
I guess that was a question to our counsel.
Oh,
So
I'm sorry.
I apologize. I didn't really direct it at you. So if it goes back to the special magistrate, that gives them an opportunity to have a relook. Then it comes back to us,
Yes,
and we will be doing this again.
yes.
Okay.
Okay.
I think what I'm hearing you say is that if this is to be sent back to the special magistrate, that we need to give it some sort of direction rather than just an opaque, just kind of, is that what I heard you say?
If the board's desire is for the magistrate to change something,
Mm-hmm.
then we need to identify, the board, needs to identify the legal insufficiencies. If the board wants the special magistrate, again, to sort of focus on it, give it more time, I wouldn't say that that requires legal insufficiency. That's really just
So
asking him
that's
to
what-
take another look.
That's what Dana's saying. We have to,
Yeah, but we don't.
what's that?
We don't have to point out legal insufficiency. We can just ask the special magistrate to have another look.
But if we zero him in on a specific portion, then that gives them the opportunity to look there.
Yeah.
Let me ask you something. Does this conversation, will you and your guidance with the special magistrate explain that the issue that we were dealing with was inside of, you know what I mean, the evidence that was brought forward? Or would it just be a send it back, look at it? Do they have input at that?
The parties do not have input.
Okay.
And I will direct the magistrate however the board asks me to. So if the board wants me to give particular instruction, focus on this or that, that's what I'll do.
And Dana's assumption that we need to give legal insufficiency in order for that to be legally heard by the special magistrate, is that true? Or what Ms. Atkinson is saying, we can just have it take a relook?
I think the property appraiser is correct. If the board is going to, for example, if the board wanted to direct the value to be changed,
Mhm.
that requires a legal insufficiency supporting that change.
Mhm.
If the directive from the board is, again, we're not comfortable with this recommended decision, I want you to look at it again, that does not require legal insufficiency. That's really outside of the rules. I can't say there's a rule that's on point for that. It's just part of the process of getting the best decision we can, I suppose.
Mhm. Chairman, do you want to make a friendly amendment to this, or are you okay with the recommended piece going forward?
Well, I think we should offer this landowner some relief. I mean, we have a statutory duty for that very purpose. How we word that, I'm not sure. Our primary responsibility is to resolve disputes between the taxpayer and the property appraiser related to a property assessment. And we do have had a special master. In my mind, I think there is reasonable evidence that's been presented in the public hearing after reviewing the recommendation of the special master that this landowner deserves some sort of relief, whether it be through a second look, or if we have the statutory authority to agree with the landowner would request which was given in a public hearing but denied.
At the end, the special magistrate writes, "The petitioner has failed to carry the burden of proof. Accordingly, the property appraiser's assessment is upheld."
I disagree with that.
Right, okay.
Yeah, and we could one option is have them take another look at that.
Mhm.
Would that'd be an evidentiary hearing then, wouldn't it? No?
No, it would be as simple as me communicating that the board is asking the special magistrate to review the recommendation again and make sure that everything really is as correct as possible based on the evidence at the hearing. It would not be based on anything presented today.
So our role, though, is to review the special magistrate's recommendation and make a final decision, which then can be distributed to all the parties.
Yes, sir.
So would we be able to make a final decision and say that the floodplain issue wasn't adequately addressed under this report?
Yes. If the board finds that's a legal insufficiency.
Oh, so we can make the argument that either the evaluation occurred illegal, not sufficiently, or that the floodplain was not adequately addressed. We could make the decision today, and it wouldn't go back to the special magistrate.
It would. Any changes have to
Okay.
go back to the special magistrate.
Okay.
The board can't make them directly.
Okay, that's,
Thank you, by the way, for going down all these
yeah.
answers and
yeah.
stuff like that. I really appreciate it.
No, my pleasure. It's my job.
Okay, so do we have a motion?
She has one. Do we want to specifically define it more, or do we want to send what we have here? Because what is, the idea is that I'm hearing a couple of different things. I didn't want the special magistrate to get it and then be like, hey, what do you want me to look over if we're not going to give them direction? But if you're saying that we as a board can say, please watch the video from the meeting
and review it, then that's one thing. Is that new evidence that has to be brought in?
It's
No.
not new evidence.
Okay, then that's sufficient. Then that's okay. Then that's fine. Okay. Call a question.
If we were to want to have specifics, and I'm only looking at the evidence that's been presented in the hearing, that is that the petitioner challenged the assessment based on the subject matter property being located in a flood zone, and it floods even in normal rainfall. And the petitioner also challenged the uniformity of assessments by nearby property, and even submitted over $500,000 cost to fill the property. If we wanted to be specific, that seems to be the issues that are really at stake here. This isn't a floodplain, and it's at great expense to resolve that floodplain problem. But I don't know. It's up to the maker of the motion.
You can make a friendly amendment to what she has, or we can send it back what it is, and if it doesn't come back the way you want, we can send it again next meeting,
Yeah, we'll do that then.
you know?
Okay.
So there's a motion on the
Motion and a
floor?
second.
Motion.
Okay, I'll second it. Or you seconded it?
It was already seconded.
Okay,
Second.
there we go.
Okay, any debate, any discussion?
Ben had.
What's
One
that?
question,
had.
sir.
Ben had.
One
Question, yes.
If I remember, the council said that the property appraiser's method was comparable sales, and you said there are no comparable sales in the area, right? Correct. So, the
But
board,
is that evidence that is not a part of the public record? Can we even consider that?
His assertion cannot be considered by
Right.
Yes.
by the special
No, we can
magistrate.
only
Right.
consider what is in this report.
Well, and the evidence that's already in the record from the hearing.
Okay, got you. Go ahead.
so under the idea of helping the magistrate do something different, because we don't want to go around in circles, direct the PA to clarify the method that they used. If it wasn't comparable sales, if that's not good, they got to use some other method, right?
And you know, if I may, those are really good points. If we send this back to the special magistrate, ask them to reconsider, we can go to the public record. We can go to the website. We can listen to the entire
Right,
the entire
That's what I-
hearing. We can hear everything, because some of this information may have been brought up, it just was not in this. So, and that's what I will do.
Yep.
We'll do that.
yep, that's what I'm
So
feeling.
it may answer some of your questions. I may be wrong. I mean, some of this data may have been presented, but we can go back and listen to that. Does that make sense? Yeah, yeah.
Yep,
Okay.
all right.
Call the question?
Call
All
the
right.
question?
All those in favor of the motion signify by saying yay.
Yay.
Nay. Shows the motion passes unanimous. That one item, and do we need to approve the rest of the items? Is that something we could do here?
You can, and I would recommend that you do.
Yeah.
Okay.
Because it'll open up Pandora's
All
box,
right.
absolutely.
1 out of 318, not bad. So, is there a motion on the table?
Move to approve
Move to approve the balance of the
the rest of the
Recommendations.
recommendations from the special master. Is there a second? Second by Commissioner Atkinson. Any debate, discussion? Seeing none, all in favor of the motion signify by saying yay.
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 Yay?
Passes unanimous.
Yep.
Any negatives? No negatives. That show the motion passes unanimously. Okay. And that was item G1, adopt the final recommendation of special magistrate with the exception of one. Okay. Number 2, approve executive.
We're not going to be able to do that.
Okay, all right. So are we done?
We still have G3.
Discuss and grant permission to advertise and set compensation rate for special magistrates. Okay.
So moved.
Is there a second?
Second?
Second, motion second, on item G3. Grant permission to advertise and set compensation rates for special magistrates. All those in favor of the motion signify by saying yea.
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 Those against, nay. Seeing no nays, passes unanimously.
Can I, before we close?
Okay.
Just wanted one item.
Yes.
If you could go find out the process about bringing back some sort of structural order in case we do have a tie, because I think that that's, for this board, would be important.
Yeah.
And I don't, and as part of that, if you can bring what it would take to bring Robert's rules as part of the recommendation, since there are none, or any other governing, you know what I mean, body for it, I think that would avoid any potential in the future.
I will do that.
Thank you.
Okay, great. Now, I think we're done. And I think that
Check our calendars.
check our calendars in case we have to come back.
I'm clear next Friday. I just checked mine. If you guys wanted, you said it would take 1 week?
I think that should be fine unless the magistrate's unavailable for some reason. I can't imagine, but
Okay,
that's the only variable.
okay.
Okay.
We can,
I checked that already.
I mean,
If it's not, because
I
by
can't do
the
next
time
Friday, given doctor's
we
Yeah, that's not good for me either.
notice and get it
Thursday
sent out
or the next
today,
Monday.
it may not be until Monday, which only gives so many days, so I just want to make sure that
I don't think that's a problem, given the scope of
be-
the meeting. It's literally just one recommendation.
I'm game.
So I think under the circumstances, it's okay.
That would work for me.
Cinco de Mayo, Monday the
Cinco de
5th.
Mayo.
I'm the same way. I have 4 on here. Yeah, because later in the afternoon doesn't work for you on that day.
Okay, how about May 5th?
Margarita Day.
Cinco de Mayo,
Available in the morning.
in the morning if
Are you
available.
available the morning of the 5th?
Are you available?
Oh, me?
Yeah,
I am at your service.
you're awesome. Thank you.
Yeah.
So it looks like we're all open on the morning of the 5th.
8:30?
Is that,
9 o'clock?
Do you
9
want
o'clock?
8:30?
No, sorry, I had
No.
8:30 on my mind
just
from
tell me
today.
8:30 and tell everybody else 9 o'clock.
8:30 for Matt and 9
Yeah.
Okay, so 9 o'clock on May 5th, we'll set a hearing date if we need. And good, thank you so much, and I'm sure our council will be available for any questions that we may
Always.
have. Thank you for your time, thank you for the staff, and
Thank you.
appreciate it and for the board and their diligence.
And gavel us out.
Robert
We
Springer.
are adjourned.
The opinions expressed by any member of the public during any period of public comment do not necessarily reflect the views or opinions of the Board of County Commissioners of Brevard County, Florida, Space Coast Government Television, or the program sponsor, and are solely those of the presenter. The Board of County Commissioners of Brevard County, Florida, Space Coast Government Television, and the program sponsor hereby expressly disclaim any and all responsibility or liability for any defamatory or slanderous statements expressed by any member of the public during any such period.